Thank you. Good day, ladies and gentlemen. Ladies and gentlemen, I trust that the consequences of the general shutdown and lockout and whatever are not that distressing, and that you are capable of proceeding with your work, and that you are even able to be productive. I won't go so far as to say that I hope you actually enjoy it, but I hope at least that that you can use your time productively. Ladies and gentlemen, the discussion that is about to take place in the next half an hour or 35 minutes or so is based upon the lecture that was scheduled for the 14th of April. It deals with the question of the constitutional position of the courts in present-day South Africa, viewed against the backdrop of the separation of powers and independence of the judiciary, against the backdrop of that principle. Ladies and gentlemen, the most important study material for purposes of this are the following items. In the first instance, it is chapter 6 of the book. That's actually the basis of the lecture and also the basis of the entire item being discussed here, theme being discussed here. There's a lot of study material, ladies and gentlemen, all mentioned there on page 7 of the tutorial letter that you've received at the beginning of the semester. I would at this stage, however, like to highlight specifically 2 further items that you have to read there, that you have to study. Firstly, ladies and gentlemen, that's now over and above chapter 6 of the book, is the very last item under that topic, below study material, that is by Teunus Roux, Professor Teunus Roux. That is actually very important for the present discussion. And then also the very first one, namely the one by Professor Shudray. It's a very long article, ladies and gentlemen, a very readable article. The same applies also to Professor Roux's article. These 3 items, ladies and gentlemen, are actually the most important for purposes of this theme. Ladies and gentlemen, just a brief note. It seems to me that eventually it is impossible to get Professor Gumede on board. I did liaise with him again, but it seems to me that his health condition unfortunately won't allow him to come and lecture with us, lecture for you, and also even impossible to make some alternative arrangement in a lecture in this particular way through a video recording. There will, however, ladies and gentlemen, be another lecture, namely by Mr. Van Zyl, Mr. Albert Van Zyl. That is the lecture that is scheduled for the 7th of April. At the moment, I am liaising with Mr. Van Zyl, and we trust that his lecture will be delivered either by way of a video recording, or if that's not possible, then at least an audio recording, so you will at least have some basic material by way of a lecture that could form the basis of that particular topic, namely the topic of the phenomenon of state capture, viewed internationally and comparatively, which obviously, as all of us know, is a very important and practical topic also for present-day South African purposes. I might mention, ladies and gentlemen, that Mr. Van Zyl is really a very professional person, really extremely suitable person for the purposes of this particular topic, since he has also been seconded by Northwest University to the Zondo Commission, where he has been working for the best part of the last year. So we are actually very, very grateful to have him on board, and I hope to report back to you very soon when that lecture will be available. Ladies and gentlemen, on the rest of the course, I will address you hopefully as quickly as possible, and also on the examination. Most probably we will have to make alternative arrangements. Other than the arrangements that we have made initially as far as the examination is concerned, which will obviously be arrangements that account for the present crises and the present panic and the present disruption as a result of the necessary arrangements that have been taken in order to combat all the consequences of the COVID-19 virus situation. It might be, ladies and gentlemen, that certain study material will also be excluded in place of other material that will be included. I'll give you some information on that, and obviously, like previously, I'll also make all that available on ClickUp. So there would be no need to search around and look around and to struggle to find study material. It will be readily available. Ladies and gentlemen, the topic for today is the question of judicial independence and impartiality. This is discussed, ladies and gentlemen, against the background of the principle of separation of powers. Because judicial independence and impartiality is actually an incidence of the principle of separation of powers. Why? Well, because the judiciary is one of the three branches, and the judiciary is actually earmarked, is highlighted more correctly, as the one institution which is really independent and really impartial. Unlike, for example, the executive and the legislature, where we find a considerable amount of overlap. This is not true as far as the judiciary is concerned. This is really the terrain. So at least the doctrine of statist individualist constitutionalism claims of of independence and impartiality. That is, in other words, of true separation. Ladies and gentlemen, this lecture is once again, like all the previous ones, a critical one. It's once again based upon a critical view that is taken upon that is taken against the claims of statist individualist constitutionalism, and in this case also against the claims of judicial independence and impartiality. What we indicate here, ladies and gentlemen, is that statist individualist constitutionalism, as we said in the lecture regarding that particular topic, the principles and the mechanisms of statist individualist constitutionalism, actually a lot is being made of the principle of judicial independence and impartiality. To my mind, and to the mind, in the mind of a variety of other scholars too, actually too much. Ladies and gentlemen, if one reads the Constitution, the most important aspect is, as far as judiciary is concerned, is Section 165. That's the starting point. It is in Section 165 where we find a subscription to the idea of judicial independence and impartiality, and the most important provisions are 165.2 and 2 and 4. I'm reading them. Sections 165.2 reads, "The courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear, favour and prejudice." 165.4 says, "Organs of state through legislative and other measures must assist and protect the courts to ensure their independence, impartiality, dignity, accessibility, and effectiveness." Ladies and gentlemen, when it comes to the nuts and bolts, to the mechanisms, in other words, in terms of which content is given to the idea of judicial independence and impartiality in South Africa, the most important institution is the Judicial Service Commission, which is provided for in Section 178 of the Constitution. Please see to it that you consult that. In Chapter 6 of the book, there's a detailed discussion on this particular topic. Ladies and gentlemen, the first aspect to highlight is this, that the Judicial Service Commission plays a very important role in the appointment of judges, also in the disciplining of judges. The Judicial Service Commission strictly speaking, is the one body upon which the whole idea of the actual functioning, the actual content of judicial independence and impartiality depend on. However, if one scrutinizes the composition of the Judicial Service Commission, ladies and gentlemen, an interesting and telling fact immediately arises. This is that 12 of the members of the Judicial Service Commission, of its 23 members, will always be supporters of the governing party. You can, in the chapter, ladies and gentlemen, with reference to the appropriate constitutional provisions, this is actually discussed in detail. There will always be a majority of 12 of the 23 members of the JSC, which will be supporters of the governing party. This is not to say that this is necessarily bad. This is also not to say that South Africa is exceptional in this regard. On the contrary, this is actually a general phenomenon of judiciaries. The fact of the matter is, ladies and gentlemen, that judiciaries are very often mandated to take important decisions of a political nature. Not in the normal course of events, not in the case of the run-of-the-mill cases, but when it comes to very important cases, cases to be decided by the highest courts, for example, the Supreme Court in the United States or the Constitutional Court in South Africa, some of the decisions taken, some of the judgments that the courts have to make, that those courts have to make, are actually judgments of a political nature. It is precisely as a result of that, ladies and gentlemen, that ordinarily it is ensured that the governing party normally does have a decisive hold, be it a subtle one, on the judiciary. That perhaps states it too boldly. At least one can say that by and large the pinnacle institution of the judiciary, such as the Constitutional Court, will always have a clear slant when it comes to political, more specifically ideological matters in favor of the governing party. The composition of the judiciary itself, to which we have referred to 3 minutes back, already confirms that. Now, ladies and gentlemen, I want to refer you to what a number of theorists in this regard said about the judiciary. I refer here, ladies and gentlemen, to theorists who are actually well known for subscribing to the idea of independence of the judiciary and impartiality of the judiciary and separation of powers. So we're not dealing here with extremists who are well known for questioning it. We're dealing with people who are actually well known for precisely the opposite, for subscribing to that. In the first instance, ladies and gentlemen, I want to refer you to Alexander Hamilton. And it's appropriate to actually read what Hamilton said in Federalist Paper number 78. Hamilton said, the judiciary on the contrary here with reference refers to the contrary of the executive and the judiciary and the legislature. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction of the strength or of the wealth of society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm for the efficacy of its judgments. Now, the moment we said it has to depend upon the efficacy, depend upon the executive for the efficacy of its judgments, then immediately we are compelled to say, well, we have to question the idea of independence of the judiciary what is more appropriate to highlight in this case is the dependence actually, the exact opposite. If one looks, for example, ladies and gentlemen, to section 1654 of the Constitution, which we have read just 10 minutes ago, that's precisely the reason why I read it, then precisely the same actually comes to the fore. It's affirmed by section 1654, because what this section actually says is that the independence must be promoted by the legislature and the executive, implying therefore that the judiciary is in fact dependent upon these institutions for its independence. Now, if it's dependent on the two other institutions, the two other branches for its independence, then strictly speaking, it cannot really be as independent as the Trite doctrine actually claims. I refer secondly, ladies and gentlemen, to Baron de Montesquieu. And as you know, he's the father of the idea, normally normally regarded as the father of the idea of separation of powers. He quite frankly acknowledged the weakness of the judiciary. In page 72 of his Spirit of the Laws, he, for example, states, the judiciary is in some measure next to nothing. Why did he say so? Precisely because of the inherent weakness of the judiciary if compared to the other two branches of government. The fact, therefore, is that the judiciary is, in a sense, not so much independent and secure, but precisely the opposite, rather dependent and insecure. The judiciary must always, and that's a very important point, the judiciary must always heed to the possibility of the wrath, the anger, in other words, of the executive, also of the legislature, if judgments are given which are regarded by the executive as too harsh, and actually going too far in scolding, in correcting, in requiring the executive to go in a particular direction. This is true, ladies and gentlemen, in South Africa, but that's also true for many other jurisdictions. Political scientist Terry Periti said that as a result of the weakness of the courts, specifically also the US Supreme Court, the US Supreme Court often has to act pragmatically instead of principally towards the other two branches in order to secure its own position, in order to make sure that it will muster the support of the two other branches. Very important, ladies and gentlemen, I refer to the article by Tienes Roux, and it's now in this context that his article comes into play. Roux refers to a number of judgments, all of which he discussed in his article, which you will obviously find when you read the article, which is, as I've said, part of the study material. He refers to a number of cases, for example, the Makwanyane case, the NNP case, the Fourie case, the NNP case, that was the case relating to barcoded IDs, that was before the 1999 election. He refers to the UDM case, that was the case relating to members of parliament changing parties, and the Fourie case, that's the case regarding the same-sex marriages case. Now, Roux indicated that strictly speaking, a court is always within a triangle. One would normally think that the court only has to take into account what the law says and give effect to the law. As a matter of fact, this is what section 1652 of the Constitution actually requires the courts to do. Roux, however, indicated, and he argued, with reference to the cases mentioned, that courts find themselves in a triangle between the law on the one hand, government in the second place, and the third position in the triangle is the public. So in other words, the court must always heed to the possible reaction, specifically the possible negative reaction that might be forthcoming from government if it gives a decision which unleashes the wrath of government and which could lead to government withholding its support from the courts. In the second case, in the third place rather, over and above the law and government, the court must also heed the possible response of the public. If you, for example, have a case which will have a considerable impact upon the public and where you have strong views of the public, then the court must also have a look at that. The court must also take that into account, because the court is to a considerable extent also dependent upon the support of the public. It must at least be seen as legitimate also in the eyes of the public. This is specifically true, ladies and gentlemen, the second two factors, namely how government should react and how the public should react, so Roux says, in South Africa, where you have a one-party dominated system. Ladies and gentlemen, I also refer here to Alexander Bickel, a US scholar, who indicated that judicial power, strictly speaking, is to a large extent a metaphorical matter and not so much a real factor. It is, strictly speaking, the court has authority, but not actual power. The court has moral authority. The court might have intellectual authority. In the normal course of events, that is in fact the case. But strictly speaking, it lacks by far, it lacks, as a matter of fact, completely the kind of power which is in the hands of the executive and to an extent also in the hands of Parliament. Ladies and gentlemen, I'm not going to discuss it, but I specifically also want to refer here to the observations of on separation of powers by Francis Fukuyama. I refer to that in chapter 5, in chapter 6, but as you know, Fukuyama's work was already also very important for the purposes of one of the first discussions that we had, namely on rule of law. I also want to refer you, ladies and gentlemen, to leading political philosopher Owen Fiss, an American, who also wrote about and who is quoted on his insights regarding the lack or the presence or absence then of judicial power. He said, just briefly, judges speak the law and can only hope that others that will be complied with. I also want to refer you, ladies and gentlemen, to the observation that was made by Dysenhouse, and this I'm going to read. It's a very long paragraph, but it's crucially important and is something that I come back to in the particular chapter on various occasions. He said the following. It's a reality that he pointed out, and that is also pointed out by Robert Dahl, somebody else that I specifically want to refer you to, and whose work you must specifically taken notice of, not only with reference at least to what is stated in chapter 6. Dahl and Dysenhouse indicated the importance of the following reality. This is the reality of the actual unity of the three so-called separate powers, rather than their doctrine-proclaimed separation. The three powers are separated in terms of institutions, personnel, and functions, but usually, and this is very important, but usually firmly unified in one single power elite. They are integral segments of one and the same dominant political leadership, informed by the same ideological assumptions, committed to achieving the same goals, yet organized on the basis of a division of labor performed by separate branches. The court ordinarily played their part as one of the branches, yet are distinctly the weakest within the overarching dominant elite. They do so in close conformity with the rest of the elite, and they are incapable of doing anything outside the consensus which is prevalent within the political elite. Few important observations are required in this regard. In the first instance, ladies and gentlemen, The term that is used here by these scholars, and which is a term that I also use profusely almost in the book, and specifically also in chapter 6 and chapter 7, is the term of the political elite. The point is that in most political dispensations, in most constitutional dispensations, you have what you can refer to as a political elite. That's the dominant factor, the dominant political factor in society. But the important thing is that from a political science point of view, which is our perspective for the moment, the political elite includes not only the leading factor within the legislature, not only the executive, but it also includes the courts, specifically the highest courts. The observations that we made right at the beginning on the composition of the Judicial Service Commission actually corroborates this. Now, the point is that when we refer to separation of powers, we must be realistic about that. What does that include? What does that refer to? There's a separation of powers as far as structures are concerned. There are 3 different structures. There's a separation as far as personnel is concerned. Do you have a separation of as far as personnel? Specifically, when it comes to judiciary, a judge cannot at the same time be a member of parliament or a minister. That we know. And lastly, obviously, you have a separation as far as functions are concerned. The judiciary can only do what the judiciary does, namely adjudicate cases. None of the other branches of government are legitimately authorized to give judgments. That is an exclusive power of the judiciary. But now the point is this. Regardless of the fact that you have these forms of separation, separation actually does not go further than that, because ordinarily, as Dahl and Deisenhouse indicated, namely, and with which I actually agree, ordinarily they are organized in the same, broadly speaking, in the same power elite. Okay? So yes, you have the separation as far as the 3 aspects are concerned that we've mentioned, which is right as far as separation of powers are concerned. But that does not detract from the fact that in the normal course of events, they are part and parcel of the same power elite, and they are unified towards achieving the same ideological goals. Now, ladies and gentlemen, obviously, and in the next lecture I will attend to that, in the normal course of events, whenever it comes to cases that relate to aspects which are of crucial ideological importance to the dominant elite, in South Africa to the governing African National Congress, when it comes to any question, and in the next lecture we will specifically discuss that, when it comes to any questions which somehow relate to an ideologically important assumption of the governing elite, it can be expected normally that the Constitutional Court, and probably also other courts, but specifically the Constitutional Court, will give judgment in favor of the governing elite of which it actually forms part. Now, ladies and gentlemen, this once again, if one do a little bit of constitutional comparison, is something which is not peculiar to South Africa. I'm not saying the South African Constitution stands out here as an exception. It is not a specific wrong of the South African Constitution. This is just simply a reality check of how constitutions actually work. And this applies to the South African Constitution and also to all other constitutions cast in the same mold as that of the South African Constitution, specifically also the US Constitution, on whose workings a lot of work has been done. Ladies and gentlemen, the fact of the matter, therefore, as Dieter Grimm, and he, for example, very important person actually, and very important commentator in this regard, because he was a judge of the German Constitutional Court, he said, obviously as a retired judge. He said, the recruitment of judges is the open flank of judicial independence. Okay, that's an acknowledgement made actually by a foremost judge. Now, ladies and gentlemen, what is being done in chapter 6 of the book is to discuss a dispute that has occurred in 2013. A dispute which occurred specifically on the Judicial Service Committee, a Judicial Service Commission. A very acrimonious dispute, which actually eventually led to two parties within the Judicial Service Commission, which one might refer to as the transformationists on the one side, namely those people which by and large subscribe to the ideological assumptions of government, the ideological assumptions that we can refer to as the ideology of transformationism, in contrast to people that more or less take a more kind of a liberal view, traditional liberals. There was a huge dispute between them regarding the appointment of judges. And that dispute actually brought to the fore the importance, it realistically brought to the fore the importance of what we're dealing with here, namely the fact that much more is actually in constitutional doctrine being made of the idea of judicial independence and specifically also of judicial impartiality than what is usually the case. The fact of the matter, ladies and gentlemen, is as follows, that whenever a court decides a matter, you can expect of the court to, that's what the doctrine says, to restrict itself whenever it comes to decisions only to the law. I go into much detail, ladies and gentlemen, on what foremost theorists say in this regard. Theorists such as Welsher, not that well-known, Bork, a little bit more well-known, and then Ronald Dworkin, quite well-known also in South Africa. What they said about what is it that courts must restrict themselves to whenever they decide cases. Well, they must decide cases only on the basis of the law. What goes hand in hand with that, ladies and gentlemen, is the idea of impartiality. And this translates into what is very often referred to as so-called party detachment. In other words, whenever a case is decided, the presiding officer or presiding officers, if you have a bench of a number of judges, must be detached to the parties before it. It must be at a distance. And it is required that such party detachment also is as important when one deals with political cases or ideological cases as in any other case. However, ladies and gentlemen, it was indicated by a number of scholars that what one actually finds, and I refer to the scholars also in chapter 6, and I want to highlight two important closely related terms here, that what actually happens in cases, in litigation, where you have ideologically sensitive matters, is what actually comes to the fore is so-called ideological relativeness, or then the ideological relativity, or then the regime relativity of judicial impartiality. In other words, yes, you do have judicial impartiality, but the impartiality is impartiality within the confines of particular ideological assumptions. It is impartiality within the confines of what is regarded as acceptable within the specific within the specific political elite, within the confines of the ideological assumptions of such elite. It is never a general, a blanket impartiality. It's always, it is never absolute, it is always relative, always qualified, relativized by the ideological assumptions of the dominant elite. Precisely for that reason, ladies and gentlemen, we can say that the ideological unity of the three separate branches of government, of governmental power, acknowledges the fact that the three powers are separate sets of bodies, each with its own personnel and functions, yet unified in a single power elite system, informed by the same ideological assumptions, and committed to achieving the same goals, and yet organized on the basis of a division of labor pertaining to each respective branch. Now, this is the conclusion that this whole idea, that this whole lecture actually comes to. It is then, in chapter 6, demonstrated with reference to disputes that emerge surrounding a number of cases that was decided in the period 2012, 2013, 2014, 2015. That's the Glenister case, Glenister 1 case, the case of Democratic Alliance versus President of the RSA. That was both a Constitutional Court judgment as well as a Supreme Court of Appeal judgment. Another case, ladies and gentlemen, DA versus acting head of the National of the National Director of Public Prosecutions, and a variety of other cases which specifically deals with the question of poor service delivery, which gave rise to the courts on numerous occasions having given judgment against government and against state departments. Now, with regard to all these cases, ladies and gentlemen, a certain measure of ideological tension has arisen between the two sectors that you have in the Judicial Service Commission on the one hand, and on the other hand, also broadly speaking, between jurists on the other hand, which sided either with particular forms of transformationism or which sided rather with a particular form of let's call it a more general and a more absolute form of judicial impartiality. Ladies and gentlemen, I've cut this short because we do have the chapter available, chapter 6 of the book. The conclusions that we reach in this chapter is startling, that's true, in the sense that we actually question many of the almost sacred assumptions regarding judicial independence and judicial impartiality. This discussion only facilitates your reading through and your studying of chapter 7 together with the other study material and specifically the two other articles that have been highlighted. The conclusion, ladies and gentlemen, that we draw is that even though there's no question that there is something like judicial independence and impartiality, and even though it is obviously true that there is something like separation of powers upon which impartiality and independence are actually built, there's actually much too much is actually being made of this. To independence is almost kind of imputed a complete independence. To impartiality is almost imputed a complete impartiality, which lose sight of the fact that in actual reality, when one looks at what actually happens, both from the point of view of observers of what actually happens within litigation, as well as from what actually happened in litigation itself, the courts eventually prove by far not as independent as the trite doctrine of statist individualist constitutionalism claims. It is very important to have a reality check on this, ladies and gentlemen, because this gives us a more clear and more realistic picture on what can actually be explained, actually be expected to be achieved through the system and through the instruments of judicial independence and impartiality and through separation of powers. Much less, in fact, than what the doctrine actually claims. Ladies and gentlemen, the last lecture that I will be giving will actually fit into this. In that lecture, we will be dealing with the question of judicial impartiality and also generally with the principle, with the idea of statist individualist constitutionalism from an hermeneutical point of view, namely from the point of view of interpretation of the Constitution. We will do that with reference to theoretical work done by specifically a variety of South African jurists, as well as with reference to judgments of the Constitutional Court. Ladies and gentlemen, in the last lecture that I plan to give on this basis, I will give the lecture in the first place, or just in the facilitation discussion. That's more or less what it is, rather, because it's not a complete lecture like a lecture in class. I will also clarify a couple of things, hopefully regarding the examination and the 1 or 2 lectures that will be conducted by people by people over and above myself, by guest lectures. It is possible, ladies and gentlemen, that as a result of the kind of crisis that we are facing owing to the corona question, we might approach the examination on a different basis, but I'll give you bring you up to date as far as that is concerned soon, and also soon enough for you to do all forms of preparation pertaining to the examination. Lastly, ladies and gentlemen, as I've indicated, it is possible that some study material will be removed and replaced with new study material that I will put in its place. I can just give you a short indication what that will be. It precisely relates to the present crisis. We are actually dealing at the moment here with the Disaster Management Act. There's the possibility of, there's the relating question of state of emergency. We didn't envisage that. We didn't contemplate that, but suddenly that's kind of practical constitutional law, and precisely for that reason it is appropriate also in a course of this kind to focus upon that. Thank you, ladies and gentlemen.